Good morning, my lords.
It is the board's intention to hear both sides on the jurisdiction issue and then move on thereafter to the merits. We intend to hear arguments on both in the time allocated.
So be it, my lord. My lord, can I just deal with... I'm entirely in your hands. There is a small preliminary issue in relation to a supplementary witness statement.
Yes, well, we are happy to take that de bene. We will look at it and decide on its relevance. I think that's a sensible way to avoid an argument about it.
Absolutely. I understood in any event that learned friend neither consented or opposed it.
That is the position, so that will be our position. Thank you very much.
Thank you very much.
May it please the court, I'll go first then on the jurisdictional arguments. If
I suppose that of course is
that
correct.
makes sense.
Thank you very much, Ms. Wakefield.
There are 4 jurisdictional issues, Your Lordships, today. They flow in chronological order, reflecting the sequence of events. So issue 1, does the Parochial Church Council, the PCC, have standing to appeal? That turns on whether the PCC duly made written representations to the commissioners in respect of the draft scheme. And we say that they didn't. That's issue 1. Issue 2 concerns the obligation on any person who intends to apply for leave to appeal in relation to the draft scheme to give notice of their intention to apply for leave by a certain date. And we say that neither the PCC nor the Reverend Yvonne Clark gave such notice, since neither was ever identified on the face of those emails, which we'll go to shortly, and the reasonable recipient would not have known on whose behalf notice was being given. And we say that the consequences set out in section 12 sub 3 of the measure, namely that it is fatal to any appeal. Issue 3, that concerns the application for leave itself. It's common ground that the application was out of time, and the question is, what's the consequence of that? Is there a general discretion to extend time on the face of the measure? If not, is this an exceptional circumstances case in which Article 6 requires an extension of time? We say no to both of those. And again, the consequences set out in section 12 sub 3 of the measure. It's fatal to any appeal.
Yes, and Article 6 only comes in if on the merits we think that the Church of England is a public authority bringing in the Human Rights Act.
Yes, that's right.
Yes.
That's right, absolutely. So if Article 6 applies to this case,
precisely,
there's the prior question of whether Article 6 applies.
Which we'll consider at the merit stage.
It may be that applies distinct from whether the Church of England, the commissioners are a public authority, in this sense that, of course, the board is a court or tribunal.
We are, yes, indeed.
And so needs to observe Article 6 where Article 6 applies, but Article 6 only applies to the determination of a civil right or obligation, and it may well be that in this case, we're not in the civil limb of Article 6. So that's the threshold issue for the application of Article 6. But
I mean, as it seemed to me, that was distinct from the question whether the Church of England is a public authority.
My Lord, it is.
So when you're talking about Article 6 in this context, it's as it applies to us as
the board.
Quite.
Yes.
Yeah, okay.
That's right, my Lord. Thank you. And then issue 4, again, concerns that application for leave itself, but this time the identity of the applicants is set out in the application. It's necessary, we say, that the application identify the applicants, and it's necessary that the reasonable recipient be in a position to identify them. The application was made on Form 1 and it only identified the PCC, not the Reverend Yvonne Clark. So that is issue 4. We've sought to agree a timetable between ourselves in relation to the jurisdictional issues. Rather optimistically, perhaps, I've hoped that I will get through my submissions in 1 hour and 10 minutes. But I did flag in the letter to the board that I may take slightly longer, and in which case I'll take it off my submissions for the substance, if I may. Before I get to the substance of those jurisdictional points, I would like to start with an apology. Your Lordships may have seen through the documents that the Commissioners have apologised for not taking this point earlier. We reiterate that apology. As soon as the point came to light, in the course of preparation for the answer in March 2023, we took it as soon as possible by way of correspondence in the first instance and then by way of application to the board. But obviously it would have been vastly preferable if it had been spotted earlier on in proceedings, and we do apologise for that. Issue 1 then, does the PCC have standing to appeal? So the core provision for the appellate right is in the measure itself, which we have behind tab 25, the authorities bundle, page 1487. Section 12(1). Any person who has duly made written representations with respect to the draft scheme may appeal to Her Majesty in Council, His Majesty, against the scheme or any provisions thereof, but only with the leave of the Judicial Committee of the Privy Council. So the focus of issue 1 is the meaning of the words duly made representations with respect to the draft scheme. The measure, of course, has the force and effect of an Act of Parliament. That's by dint of Section 4 of the Church of England Assembly Powers Act 1919, which is in the bundle. I'll take you through the measure so that you can properly understand what those words mean, if I may. So if we start just by way of background in Section 1, it shall be the duty of any person or body carrying out functions under this measure, sorry, I should have said 1468 for those of you looking online, under this measure to have due regard to the furtherance of the mission of the Church of England. Mission is a defined term in section 106, page 1596. It means the whole mission of the Church of England, pastoral, evangelistic, social and ecumenical. If we go back to the earlier provisions in the bundle, we go to section 3, functions of the mission and pastoral.
Sorry, where are we going now?
Sorry, that's 1470. Sorry, my lord.
Yes, you're going at quite a pace.
Yeah, you have to allow us to actually get to
back
to the document.
I'm sorry, slow down. So we're in section 3, page 1470.
Yes.
We're dealing here with the diocesan, in this case the Diocese of Southwark, Mission and Pastoral Committee. Under section 2 on the previous page, it deals with their appointment. Section 3, this is their functions. Function 3 sub 1, carrying out any of its functions, the MPC shall, without prejudice to section 1, which I've taken your lordships to, have regard to worship, mission and community as central to the life and work of the Church of England. Under 2, we have carrying out any of its functions, also have regard to A, financial implications for the diocese, Church of England as a whole, C, traditions, needs and characteristics of particular parishes. I should say, when I was in taking you to these provisions, I'm slightly opening up provisions we'll be looking at later as well.
Yes.
Then 3, A, we're in the duty of the MPC to make or assist in making better provision for the cure of souls in the diocese as a whole, and to the extent that the committee thinks appropriate in particular parts of the diocese or in particular parishes. And then the core provision for issue 1 is over the page, on page 1471, F, at the top of the page, where it considers it desirable to make recommendations to the bishop in accordance with section 6 or 21 for any of the matters for which provision may be made under this measure by a pastoral scheme or order. That takes us to section 6, relevantly for issue 1, which is on page 1474. Formulation and submission to the bishop of draft proposals. So 6 sub 1, I don't know if your lordships will have that, page 1474. Before deciding to make any recommendation to the bishop, the MPC shall, so far as may be practicable, ascertain the views of the interested parties or invite them to express their views on the recommendations the committee proposes to make, or, if the committee has yet to formulate recommendations, on the issues which the committee considers need to be addressed. And in section 2 we have that definition of interested parties, includes incumbent and we see in C, a PCC of any parish which would be affected. So I note the statutory language here in 6 sub 1. The obligation is just to ascertain as far as practicable or to invite. The language used is views rather than representations or written representations. The thing which they're being asked about isn't the draft scheme doesn't exist yet. It's recommendations, or where recommendations are yet to be formulated, the issues, and it's limited to interested parties, and plainly there's no time limit imposed there either. It's just, so far as practicable, try and ascertain those views. Over the page, in section 6, sub 7, where the committee has decided to make recommendations, it shall formulate them in draft proposals. So that's the next thing that happens. Recommendations turn into draft proposals, and they are submitted to the bishop. And the bishop may, with the agreement of the committee, make such amendments as appear to him desirable, and annexed to those proposals are a statement of the views of interested parties. We then go to section 7 on page 1477. This is the approval by the bishop of the draft proposals. We see that under section 7.1. And then in this case, under B, what happened is he sent the draft proposals to the commissioners without any amendments, that he could amend them, for the preparation of a draft scheme. And having done that, the bishop so informs the MPC. So it's at that stage, the proposals were sent to the commissioners for the commissioners to turn the proposals into a draft scheme. Section 7 still, in sub 4, where the proposals are sent to the commissioners under subsection 1b, the commissioners shall, on receipt of the proposals, consider whether the procedures set out in section 6 have been properly complied with. We looked at some of those. And then, if they think they have, the commissioners shall prepare the draft scheme, giving effect to the proposals, again with any amendments. So we now have the draft scheme.
Yeah, so it's the task of the commissioners to make sure that the prior procedure has been carried out before they move on to the creation of the draft scheme.
Exactly so. Exactly so, my lord. And of course, the draft scheme can be changed, can be amended at the various stages by the bishop, and it can be amended again by the commissioners. So we then get to section 9, which is on page 1481. The heading Notice and Publication of Draft Scheme. And if we start with 1A, the commissioners shall, in the case of every draft scheme or order, publish the draft online. Oh, sorry, I'm in 1BA. The commissioners shall serve a copy of any draft scheme prepared by them under section 7.5, that's the one we just looked at, on each of the interested parties, together with such a notice as is mentioned in subsection 1. So that causes us to go to subsection 1. Subsection 1 itself arises in a different case when the MPC has made the draft scheme. But if we go to the second half of the sentence, starting with the word together, that describes the notice. Together with a notice stating that, and here we have the words, written representations, with respect thereto, may be made to the commissioners, not later than a date specified in the notice, being a date not less than 28 days after the service of the notice. So here we've got the language written representations, we have the subject matter of the written representations, it's the draft scheme, that's what the thereto is referring to, recipient of the representations, the commissioners, we have a formal notice obligation, it's not a best endeavours so far as practicable, it's a formal obligation, and we have a minimum time period, so that's all consonant with the importance of this stage. We also have, in this same section, 1b, which I began reading to your lordships a moment ago, and 3, broader but equivalent notice requirements in relation to the world at large, essentially. So one publishes the notice online and again invites written representations by a date published on the face of the notice, that's 1b. And in 3, the notice is sent to the churches which may be affected by the draft scheme, and is affixed to the door. And in the services which take place at that church, it's read aloud, and it's made sure that everyone knows that they have that right to duly make written representations. Still in section 9, at 4, sub 4, the commissioners shall consider any written representations duly made. So there we have the words, written representations duly made. I say that plainly means written representations made pursuant to the section 9 procedure.
So this is where, sorry?
On subsection 4.
Subsection 4.
1482. So we're still in section 9. We give the notice inviting written representations in relation to the draft scheme, and then we receive those written representations duly made, and under subsection 4, we consider them. And under subsection 5, we are granted a power to extend time for the making of those written representations before or after the end of the period, and any representations made within the period so extended shall be deemed to be duly made. So again, that tells us, I say that timing is a core aspect of those representations being duly made, and that's a reference to the 28-day period. If we carry on through the scheme, we get to section 11, page 1485. And in subsections 1 and 2, we see different things happen depending on whether we've received written representations or not. So under subsection 1, where no representations with respect to any such draft scheme have been duly made, and the Commissioners are of the opinion that the draft scheme should be made, and we don't propose to amend it further, we seal the copy of the draft scheme and so make the scheme. So it happens. Under 2, where representations with respect to any such draft scheme have been duly made, and having considered those representations, the Commission...
And sorry, can I just ask about sub 1? That doesn't say written representations duly made. Is that to cover the possibility of all representations being allowed to be made in the discretion of the Commissioners under section 9(4)?
I think that's right, Ronald.
Okay.
I think that's right. It certainly is the case that under 9(4), of course, we can have that sort of oral hearing. We did have one in this case, and persons can come to the oral hearing and make submissions orally, which they haven't made in writing. There's also a general power under section 19 sub 3 for the Commissioners essentially to consider any representations that they receive at all, and embark on any consultation or inquiries they see fit. And again, that's a broader evidence gathering power. The reason why I'm pausing slightly in relation to section 11(1) and 2 is it does appear to me that it's written as if it's a binary choice. Either you have received the relevant representations or you haven't received those representations. But it may be
Well, somebody could have been an interested party, perhaps, and not have made a written representation, at least theoretically.
That's true, that's true. But the core point, perhaps, under section 11 sub 2a is the language there. We see the re-emergence of the word written. So 11 sub 2a, serve on the persons who duly made written representations with respect to the draft scheme, notice of the Commission's decision with respect to the representations, together with a statement in writing of the reasons therefore, and then critically, in subsection 3, a notice under subsection 2 shall inform persons who have duly made written representations with respect to the draft scheme of their rights on obtaining the leave of the Judicial Committee of the Privy Council to appeal to Her Majesty in Council, His Majesty, and shall specify the date, being a date not less than 28 days after the service of the notice, on or before which notice of intention to apply for such leave must be given. So there we clearly see the re-emergence of written representations, and I've taken you through section 9 where we see written representations emphasised the whole way through. This is plainly notification of the appellate right, which I took you to at the beginning of my submissions on this point, section 12(1). It must have the same scope as that. It must also be the case, of course, that the Commissioners know exactly who it is that they have to give that notice to, and certainty in that regard is something which I'll come to. I've already referred to section 19(3), the broader evidence gathering power, but if I might also take you now just to schedule 2. So section 12, which deals with appeals to the Privy Council, subsection 2 of section 12 says schedule 2 shall apply to applications for leave to appeal and to appeals to Her Majesty in Council under this section. We go to Schedule 2.
I think it's 1610, but
It's
you need to tell us what the page.
1610, I'm grateful, my Lord. And we see, and we'll come to this in relation to issue 2, that any person who intends to apply for leave to appeal has to comply with the date set out in that notice and to the section 11 provisions in relation to the notice. And then in paragraph 3, the registrar has to be satisfied that the notice was given by a person who duly made representations with respect to the scheme in question. And I do note that the word in writing is missing, but I say plainly it has to have the same construction as the appellate right itself, section 12.1. The purpose of this filter is to check that there is really standing on the part of the person who's giving notice of their intention. So turning to my learned friend's submissions on this point, he says three things.
I mean, just on that, I mean,
Yeah.
it is very slightly curious that within section 11 one moves between reference just to representations, and we know that there can be representations which aren't written.
Yeah. It's very strange that it should give rise to an appellate right in those who made written representations, even though the thing that triggers it might be a thing that wasn't the written representation.
Yes, and why someone that made, say, oral representations with the leave of the commissioners should be excluded from a right of appeal. And why, if they've made a good point and they turned up as part of the procedure to make that point,
Yeah.
why are they excluded from being able to appeal?
So, Milo, when one looks at the language of section 12.1, one sees plainly that it has to be in writing. So, with respect, that objection, it would run regardless of the set of representations one was considering, and it would have to essentially delete the word written. The reason why I say the appellate right is circumscribed is that the nature of these draft schemes is that they're important decisions, and they're important decisions that may affect many, many people. They may affect thousands of people, and in that sense, they're rather like a planning decision or something like that, perhaps. And so one does have an appellate right. It's an important appellate right, but of course it's a circumscribed appellate right, and there's an important standing provision. And given the breadth and permutations and penetrations of our notice requirements under section 11, and the clarity with which we say to people, you have to make written representations now within this time limit, it's entirely fair and sensible for the legislature to have struck this balance where it's very carefully calibrated. It identifies what you need to do to have standing, and there really is no basis, I say, to embroider that. And we'll come to this in issue 2, perhaps more than in issue 1. But we do see in section 12.3, and this is the provision that I'll come back to repeatedly, as I indicated in my opening, that there is a list here of various acts or omissions, including no notice of intention to apply for leave having been given on or before the date specified in the section.
Sorry, where are we looking now?
Section 12, sub 3, my lord.
1487. On your approach, there is really a rather strict procedure here.
There is.
With tight time limits. Is there a historical reason underlying the strictness of the procedure? Do you know?
I don't have an obvious answer in the sense of, oh yes, there was a case that considered it and explained it in that way, and nor do I have sight of something equivalent to the Travaux. But I do say it's sensible to have a very strict procedure because in a sense, it's the having of an appeal that might be seen as slightly surprising. Obviously, it's an important decision, and obviously people need to be able to come and exercise that appellate right, it having been granted, and obviously it's a full appeal on the merits, and I don't shy away from any of those things. But nevertheless, for all the reasons which I'll come to when I address why we're not a public authority, this is fundamentally, we say, a matter of the internal organisation of the church. Parishes are important things, but they're important for ecclesiastical purposes.
It's the cure of souls.
The cure of souls, my lord, the cure of souls. So it would be wrong to call it strict and narrow, because in a way it's very generous. There is no standing requirement to make the written representations. Anyone can make them, It's published to the world at large. Nowadays, under the modern regime, it's on the internet. That is generous, and the test applied by the board, at least in ground 3, in a conventional appeal, or ground 3 in this appeal, again, is a generous appeal. And the checks and balances for that, the swings and roundabouts, is that you do properly have to have standing.
Yes.
It's not a particularly surprising standing requirement. This is an elaborate procedure with many different stages in it. But when it comes to the commissioners, when the decision's made, this is what the draft scheme will look like. Other things were recommendations, they were proposals, but this is what the draft scheme will look like. We go out, we say, tell us what you think about it. For that to be the thing that generates the standing requirement, I say is perfectly sensible.
Yes, but I mean, other than section 9.5, where there is a power to extend the period for written representations, there is very little flexibility in this procedure, and you say that's deliberate, because you'll be coming back to it, no doubt, but 12.3 is written in pretty stark terms.
In very stark terms.
Because it's not empowering the commissioners to make the scheme, it's telling them they have to.
We have to. We have no choice now. Absolutely. It's deliberately strict in that way. And that gives certainty to everyone else who's affected by it. All the third-party rights, all those persons who didn't object, and for whom things may change as a consequence of the scheme. So of course it's important that it's efficient and effective and that it moves forward at a proper speed, absent a duly constituted appeal.
Yes.
So the first thing my learned friend says is that views expressed in the section 6 stage, the DMPC stage, which I took your lordships to, that those should count as written representations duly made. I say that that's plainly wrong on the face of the measure. It really does terrible violence to the statutory language used, and it also makes no sense because, of course, views which may or may not have been expressed at that moment in relation to those earlier recommendations may have been expressed orally, maybe in writing, maybe a mixture of two, and things have moved on massively. And, of course, the commissioners, and I took you to this, when they're exercising their Section 11 function and determining who they have to give that statutory notice to in relation to the appellate right, they need to know really clearly who's made a relevant written representation. Well, they do know if they've received them all within the 28-day deadline themselves, but they don't know if they need to conduct some kind of unlimited archaeology into the history of the case. So I say that really doesn't work at all. There is in the bundles, I think I probably don't need to take your lordships to it, but the Little Lee case, which was one of these appeals to the board, it's page 2253. But in that case, similarly, a PCC missed the boat, I suppose, if one could put it that way. And they thought their views had been communicated to the Archdeacon and that they'd be taken forward in that way. And the board held, be that as it may, having failed to object in due time and manner, they have no locus standi to appeal to His Majesty in Council, and they have not sought to do so. So it's different because in that case they didn't even seek to appeal, but they recognised that their misapprehension, that just being vaguely in the mix at an earlier time, meant that one didn't need to reply to anything subsequently. It doesn't make up for the standing deficiency. It doesn't confer standing. So that's point one. Did the DMPC process work to confer standing? No. Point two, are late representations duly made? So the deadline for the Section 9 representations in this case was the 7th of September 2020. That's at page 307.
So could you give me the date again? I'm sorry.
It's 7th of September 2020.
Page reference again.
307. So this is the Section 9 notice. And I take you to it, my lords, principally to show that we have the date there, Monday the 7th of September, halfway down the page, clearly emboldened. If your lordships are interested, you can turn over the page and see the various other notice obligations which I've taken your lordships to already. The PCC secretaries, sticking it on the door of the church, all of that, the announcements and so on. At page 547 of the bundle, we have representations from the PCC dated the 25th of November 2020. So that's page 547. Now, these weren't purportedly in response to that notice that I've just taken your lordships to. Instead, they were in response to a subsequent invitation by email sent by the commissioners on the 19th of November 2020. We can see that in the first sentence of this response. That was pursuant to the section 19.3 powers. What happened in this case is we got all the written representations, we sent them to the bishop gave his views, we sent the bishop's views out again, said under section 19 sub 3, everyone respond to what the bishop said. We sent that back to the bishop and got his views. So it really was an elaborate process going backwards and forwards. These are late. These do not fall within the 28 days of the section 9 notice. But I take you to them so that you can see what submissions from the PCC might look like. We have the headed note paper, the top right...
Sorry, do we have the page reference for the 19th November email?
It is page 530.
Thank you.
And I should say in this case we have a very helpful, or I found it helpful, chronology with all of the page references down the right-hand column, so that does have all of these different steps set out in it. The headed note paper, right-hand corner, the PCC secretary, the first paragraph, second sentence, the PCC of All Saints Spring Park is saddened to read the bishop's response, and so on. And then if we turn over the pages to page 551, we see that it's signed James Clark, PCC secretary, on behalf of the PCC, All Saints Spring Park. So we say that plainly is made by the PCC, but it's late. It's very late. And I say that that lateness is not curable in the present case. I say it's impossible to read any further provision to extend time on top of the measure, supplemental to that which we have in section 9 sub 5, and there has been no extension of time. So these were not duly made. We cannot treat them as if they're duly made. They weren't. If I need an authority for the proposition that duly made normally means in time, then we have Middlesex County Council and the Minister of Housing for Local Government in the bundles. That's page 2112. I don't need to take your lordships to it. And then the third and final submission of my learned friend is that representations made by James Clark, who we've seen as the PCC secretary, and which were in time, constitute such representations. But Mr. Clark is also the Reverend Yvonne Clark's son, and made those representations, I say, in his personal capacity as her son. So those are at page 427.
I think he used a PCC email address to send it, is that right?
He did, yeah.
But you say in its terms it's a personal representation.
Absolutely.
In the capacity of being a relative of the priest in question.
Yeah, absolutely, absolutely. So we see, if one were to read through these representations, they relate to his experience as his mother's son and speaking effusively in praise of his mother. And then we see on page 433, halfway down the page, James Clark, son of the Reverend Yvonne Clark. I've described how on the 19th of November there was that email inviting further representations, and James Clark, in response to that email, made further representations on his own behalf at the same time as making those representations as the secretary of the PCC. So he put in two documents that time round, a PCC document and follow-up representations on his own account. Those are at page 532. 532 of the bundle, and we have the date at the top, 22nd of November 2020, and he says, I write further in reference to my representations. So he's referring back to those in-time duly made representations on his own behalf. And then on page 535, regards James. And again, the substance of the representations are personal. So I'm afraid we end up in a position where there simply are no in-time representations made on behalf of the PCC. They engaged in the first bit of the process, section 6 DMPC, but they don't count under the statutory regime. In the 28-day period, clearly notified to everyone in bold, pinned upon the church door, read out in the services, no representations made on behalf of the PCC, only by James Clark in his personal capacity. And then in the subsequent round of representations, the follow-up, section 19, sub 3, invitation, yes, they came in from the PCC, also from James Clark in his personal capacity, but that's too late. They were out of time, they weren't duly made. So that's issue 1, jurisdictional issue 1. I say the PCC has no standing. They didn't duly make written representations in relation to the draft scheme. Issue 2. Did either or both of the PCC and the Reverend Yvonne Clark give notice of their intention to seek leave to appeal? So we've already looked at the measure, and we've looked at sections 11.2 to 4, the section 11 notice, together. And the commissioners give notice of the appellate right. Perhaps I'll take your lordships to, rather than asking everyone to remember it. So we're at page 1485. Section 11, so representations have all been received. The commissioners under section 11.2 have nevertheless decided to go ahead with the draft scheme, and we serve the notice of the appeal rights on all those who duly made written representations, and under B we serve a copy of that notice on interested parties. We go to Schedule 1.
Presumably none was served on the council.
It was served on the council, Lord.
Because they're an interested party.
They're an interested party. It may well be, we don't have evidence on that, but there may in general have been a confusion as to their status. I think that's fair to say. But the PCC would always be served with the notice. The incumbent would always be served with the notice. But it's certainly a singular notice addressed to everyone directly, so there wasn't a different notice saying this is for your information only.
Right.
I think there has been a confusion as to status throughout this. So if we go to Schedule 2, in Schedule 2, Sub 1, any person who intends to apply for leave to appeal to Her Majesty in Council under Section 12 shall, on or before the date specified in the notice served on him or her under Section 11.2, send written notice of his or her intention to the Registrar of the Privy Council. The notice should be sent by registered post, and so on. So we have that obligation in Section 1, in paragraph 1, and then paragraph 3, I take your lordships to this before, on page 1612, we have the obligation on the registrar to consider whether that person giving notice of their intention does have a standing. If we go back through the measure to section 12...
Sorry, just on paragraph 1,
yes.
It's probably worth emphasising that this is notice of intention to apply for leave to appeal. It's not the application itself, so there seems to be a filter process that you go through before you get to actually making your application for
Absolutely, absolutely. So the first thing that happens is you give notice of intention, the registrar exercises the filtering function, and then we can just turn over the page now, since we're here in paragraph 4 of 1613. Within the period of 28 days, starting with notification from the registrar of her decision, one has to make the application for leave. Going page 1487 in section 12.3, we have the identification of core acts or omissions in the life of any potential appeal, and the mandatory consequence that if that thing happens or doesn't happen, the commissioners shall make the scheme. And in 12.3 sub A, if no notice of intention to apply for leave to appeal is given on or before the date specified in the notice served under 11 sub 2, then we go to the bottom, the commissioners shall seal a copy of the draft scheme and so make the scheme.
Which they haven't done, have they?
We haven't, my lord. And these points having arisen rather late in the day, and we don't say that's subject to a timing requirement, though obviously we'll want to be aware of it sooner, one would make the draft scheme. The core thing is we have no discretion as to what to do. To complete the picture...
So, although you have something that's equivalent of a statutory obligation to make a scheme, you're holding your hand pending this appeal. Is that the situation?
We are, my lord. And of course, my learned friend says that we don't have that power for reasons which he'll explain. And also, of course, relies on the cases to say that if an issue like that is in dispute, we should go to the court to find out before we press ahead. The final provision, which I would take your lordships to, is page 1490, section 14. Validity and operation of schemes. The validity of a scheme made by the commissioners under this part shall not be questioned in any legal proceedings. So once we go ahead to seal and so make the scheme, that's that. It's no longer challengeable. There are 4 principal documents which I'd like to take you to in relation to issue 2. So first of all then, the notice which the commissioners served under section 11, that's on page 67. So page 67 is entitled Right to Seek Leave to Appeal Against the Commissioner's Decision. It sets out in paragraph 1 the language of section 12 sub 1. And then we see in the second paragraph, any person who wishes to apply for leave to appeal must first send notice of his or her intention to the registrar of the Judicial Committee by email, copying in a church representative, and then emboldened by the 7th of November 2021. The second document is at page 751 of the bundle. So this is an email from Lee Day with the subject format query, mission and pastoral measure 2011, format and notice of application for leave to appeal to the Judicial Committee of the Privy Council. We see the first paragraph, they say they're writing to inquire about the correct format. They attach the notice. And they say they've been given, and then they underline, they've been given till the 7th of November 2021. We'll say we, as the appellant, have been given until the 7th of November 2021. Of course, that, in a sense, it begs the question itself, who is the appellant? But anyway, knowledge of the deadline is stated on the face of that email. And we see that it goes on to ask how best
According to the rules, it's meant to be served by registered post, but the notice itself said it could be served by email.
It did, my lord. I mean, it was in COVID times, and of course one of the things which we'll be coming to in the course of my submissions is the sort of infelicity or procedural non-compliance with a provision which may be cured or which may not have the consequence of total invalidity, sine die, and the sort of failure which is incurable. And I'm not raising any of the peripheral arguable, well, maybe it might have been wrong for that reason, maybe it might have been wrong for another reason. I'm not raising any of those other points. There are a host of other points I could take were there world enough and time. But I say, for issue 2, the one thing which a notice absolutely has to do is identify who the notifying party is. That's my submission for issue 2. And I'm taking your lordships through these emails so that your lordships can see that the identity of the applicant, the appellant, but the applicant for leave, is never identified. So that is invalid notice. It has the consequence, I say, that no notice was given. That's my submission. But it may well be that there were other parts of the regime which were not complied with, but which are less, or maybe less fatal. So we see in that email requests in relation to formatting. We represent the appellant. The word appellant is used, but no identification of who that person or persons may be.
I think it might be said that the email also betrays a bit of confusion about this difference between notice of intention to apply for leave to appeal and the application for leave to appeal itself, because they're asking for the format of the to apply for leave to appeal.
It's true.
Anyway, I'm not sure it takes us anywhere, but
No,
just to point out that they are
Jumping the gun a bit.
have lost sight of the two-stage process, that there's the filter and then you have application for permission to appeal.
I think that's right. I think that's fair, my lord.
Yes, I mean, the questions they ask seem to be related to the second stage.
Yes. But the timing, I think, is the 7th of November. I think that's the first stage, isn't it?
It is.
Yes, I mean, well, they mention when they refer to the 7th of December, they recognise it as a time limit for notice of intention to appeal. Yeah. But then they go on to ask questions about the next stage.
They do. I mean, the reality is, of course, in litigation, one may well be preparing the two things in parallel. So perhaps one could ask the two questions in the same document. In any event, at the top of that page, 751, we have a response from the registry, the 29th of October, saying thank you very much, and please find attached the registrar's letter of today's date. We have that over the page. It's at page 754. It's addressed to the individual at lead A. It has the heading benefice of, and then the 3 affected parishes. Of course, it's only actually the benefice of All Saints Spring Park which is affected by the draft scheme. And the scheme goes broader than benefices. And the first paragraph says, I acknowledge receipt of your email giving written notice of your intention to apply for leave to appeal. So acknowledgement of receipt. No indication of the considerations under paragraph 3, whether the person duly made those representations. And then a setting out of what needs to happen next. So you've now got 28 days, this is the paragraph 4 indication, 28 days to make your application for leave to appeal.
Was it sent to the commissioners, this notice?
We saw it as well. Oh, when you said that, I'm not sure whether we saw it at the time. Yes, we did. We did. We see that at the top of page 751, my lord.
Oh, I see, the email shows it.
It's an email, yeah, absolutely. So if we then turn over the page to page 750, on the 5th of November, so that's a week later, a further email from lead A saying, I just wanted to clarify that in the earlier email, we were writing to inquire as to the correct format to apply for leave, rather than to give written notice of our intention to apply for leave. So that's my Lord Sales's point, that they were conflating the two things or asking about one thing rather than giving notice of the other. So they're related to correct format and so on for grounds of appeal. The final paragraph, in line with the notice provided by the Church Commissioners, so that's our notice at page 67, we would now request that this correspondence act as our notice of our intention to apply for leave to appeal to the Judicial Committee against the scheme for the benefice.
Would you accept that that would have been a valid notice if it had identified on whose behalf it was given?
For present purposes, yes, my lord. Yeah. It really is just the communication of I, person X, intend to apply for leave to appeal. And I'll take your lordships very briefly to the cases, but I'm sure you're very familiar with them already. So again, no identification at all of on whose behalf that notice is given. That's the point. And then time expires. So, turning to my submissions, in our case, we cite a considerable volume of authorities on this point, paragraphs 10, paragraphs 27 to 35 of our case. But it is in my submission important not to lose sight of the fundamentally fairly straightforward nature of my submission, which is that, firstly, there's an obligation on an applicant to give notice of their intention to seek leave to appeal. We see that on the face of the measure and throughout it. Secondly, section 12 sub 3, in the absence of that notice being given, the commissioners are under an obligation to make the scheme, and the scheme once made is safe from the scrutiny of the courts. And then thirdly, as to what constitutes a notice, I say, as I just said to my Lord Legate, it definitely needs to identify who is giving the notice. And fourthly, my final point, it makes no difference that the registrar wrongly responded to the email of the 28th of October, essentially saying, thanks very much, let's move forward. That doesn't do anything.
I suppose without knowing on whose behalf it's given, the registrar couldn't check that it was made by somebody who had standing.
No, absolutely not. And it can't be a determination of that issue. It's just impossible for her to have determined it.
So you made 4 points. The third one was you said that absent the notice, the church commissioners had to make the scheme, which was then protected from challenge by the courts. And then you made a third point, I missed it.
So the third point is what constitutes a notice. It definitely needs to identify the person giving the notice.
That's right.
And then the fourth was that it makes no difference that the registrar sent the letter that she sent.
Yes, so the key point throughout is that the communications didn't identify the appellant.
Absolutely.
Yes.
Absolutely, my lord.
Yeah, and yes, and I think flowing from that, as I understand, you're making 2 points. One is just generally, a notice should identify by whom it's given, but you say that has particular force here, given the filter mechanism in paragraph 3 of Schedule 2, which is what I understood my Lord Legate to be drawing attention to, that it's not just receiving a notice, let's move on. The registrar is supposed to be checking something.
Yeah, absolutely, my lord. Absolutely. So, with an eye on the time, I'll take my submissions on this relatively quickly, at least on the consequence of a failure to give a notice. So you have my reliance on section 12 sub 3. We also know that there are other parts of the measure which do confer an ability to extend time. Section 9 sub 5, I took your lordships to. The registrar's consideration itself under paragraph 3 is not time limited. And subsequent non-prosecution, which we don't get to today, but in paragraph 6 and 11 of Schedule 2, so where there's a delay in lodging the petition of appeal, again, the registrar has a power to extend time. So we see this is one of those schemes where the legislature has identified occasions where there is a power to extend time. Those are not the occasions where we have a section 12 sub 3 consequence. So some acts and omissions elevated, some softer consequences. I may deal with this more in reply because I think my learned friend relies on synergy here, but I say it's just not a synergy case because we have a clear statutory indication of the consequence of non-compliance. In the bundles, we have the well-known authorities. On that point, Shahid, of course, most obviously, perhaps. Trail riders, the Supreme Court, in which, of course, Lord Neuberger that said that when this sort of error went to jurisdiction, it was non-curable, but of course it's a matter of statutory construction. And then the recent case of the Crown and Leyden, the very recent judgment of the Lady Chief Justice, which perhaps I'll take you to quickly, is at page 2779. The 2779, in paragraph 13 of Her Ladyship's judgment, we have the relevant statutory regime, that's the power to order a retrial, and that power including the words, after the end of 2 months from the date of the order for his retrial, he may not be arraigned on an indictment preferred in pursuance of such a direction unless the Court of Appeal gives leave. Then in paragraph 17 onwards, we have Her Ladyship considering synergy, and of course the core question being whether Parliament, the legislature, can fairly be intended to have intended total invalidity, and the considerations of fairness of proceedings or prejudice to the defence in that particular case would only arise if, on a proper construction of the statute, Parliament did not so intend. And Her Ladyship worked through the normal principles of statutory construction, looking at the clear words of the statute and so on, and then in paragraphs 23, paying particular attention to the importance of adhering to statutory language and the imposition of time requirements, as in this case, where it goes to jurisdiction. And we see in paragraph 24, the last sentence, which is perhaps helpful, in which Her Ladyship indicates there is no modern approach, which means that the only thing we should ever think about is, in any particular case, how it works on the facts present, like a prejudice to a defendant and so on. But all of those, I think, should hopefully be common ground and be accepted. Synergy only applies when there's a statutory question at large, not when the statute says to you, and if you don't comply, then X, which is the world we're in now.
I should perhaps just mention that there is an application to the Supreme Court for permission to appeal in relation to Labour, but I'm not sure it affects the points that you're making, which are very general points as to construction of statute.
Thank you very much. Thank you. So the question then is, what constitutes a notice? And I say, you have this point already, the basic thing that a notice has to do in any case is identify the notifier, and that with bells on in the present case. Pease and Carter, we have in the bundle at page 2273. As we see from the head note, a notice of proceedings for possession was served on tenants, and statute required the notice should inform the tenants proceedings would start no earlier than a specified date. The date must be no earlier than the expiry of a period of 2 weeks from the date of service of the notice, and essentially there was a typographical error. Rather than giving the date of the 26th of November 2018, the notice gave the date 26th of November 2017. Now, Lord Justice Arnold's judgment starts at page 2275, but we can go to 2279, I think. Paragraph 13. And his lordship canvasses over the following paragraphs the important authorities considering statutory notices, starting, of course, with paragraph 16, or paragraph 14, Manai and Eagle, and the core test being how it would be understood by the reasonable recipient in context. So when you ask yourself, what does that notice convey? If it's an obvious typo, for example, then the reasonable recipient would have known that, and so that isn't a ground for invalidity. It remains necessary to consider whether the notice complies with the statutory requirements. So here we're in paragraph 39, which is page 2286. His lordship summarises where he gets to at the end of his survey of the law. One, the point I've just made, statutory notice interpreted as it would be read by a reasonable recipient in context. Two, the point I've just made, typo point, on error which would be apparent in context. Three, necessary to consider whether, so interpreted, it complies with the relevant statutory requirements, and then four, in that particular regime, substantially to the same effect, whether that works. If I take you now, of course, statutory context in our case is very much that the registrar must be able to perform her function.
Sorry, and where does he pick up the quotation substantially to the same effect from?
Sorry, I didn't hear that, my lord.
Sorry, in little 4, he's put substantially to the same effect in quote marks. Where did he pick up that quotation from?
So that's in the legislation
That's
which
the
applies in the
legislation.
tenancy context, as I understand
Okay.
it. My junior will correct me if I'm wrong. No, I'm being nodded at, which is reassuring.
So that is the
So that's
statutory test that he
specific to
was
that.
applying.
Exactly, specific to that case. The other case is Newbold and the Coal Authority, which is at page 2146. So we see in the head note, this concerned the completion of standard form damages notices under the Coal Mining Subsidence Act. And the notice gave only the name of one brother as a claimant, but an attached notice on ownership indicated that the freehold was owned by 3 brothers, and that was said to render the notice invalid. If we go to paragraph 57, which is at page 2164, we see Sir Stanley Burton work through the various options for the notice by reference to him and his personal assistant. So we see in paragraph 58, if I ask my personal assistant to type up a notice to quit in my name and to post it, the notice is given by me, not my personal assistant. If I ask her to sign it in my name or expressly on my behalf and post it, it remains a notice given by me, it's not a notice given by her. 59. If without my authority someone produces a notice in my name, the notice is not given by me, even if I'm named as the person in the notice. And then in 60, the third possibility is that my personal assistant, having been authorised by me to produce and send a notice from me, in error puts someone else's name in the notice. In this case, it seems to me that the notice is not one given by me, unless it's obvious to the recipient that the name of the giver of the notice is an error, and both that it is I who authorised the giving of the notice, and that the error was to substitute the incorrect name for my name. This is because a notice is by its nature a communication, and must be understood by the recipient to have been given by me. It's not sufficient to point out that the notice is invalid unless I'm held to have given it. To do so would be to depart from the requirements of the statute or contract pursuant to which notice is served. And he goes on in the judgment. But I say that that's entirely correct, that the core function of a notice is that kind of communication, and that we know, because of Pease and Carter, of course, that one construes that communication in the context of the specific statutory regime. So as I said when I answered my Lord Legate's question earlier, whatever else the notice had to do, it had to say, I, person X, am giving notice.
He's not, of course, actually considering this situation. He's talking about the wrong name.
He's talking about the wrong name.
Yeah, it's obvious that it's intended to be given on behalf of somebody else, but it's not apparent who the somebody else is.
Yeah.
It's a case of an unnamed principle.
It's an unnamed principle, exactly so, my Lord. And I say that means that it's invalid notice. And so the consequence in section 12(3) follows. So it's not suggested by my learned friend, he'll come to his submissions in due course, but it's not suggested that the error can be cured, but rather that compliance with this part of the process is optional, I think. I'm not sure how that's meant to work, because of course one needs to give intention under the measure. There's no way around it. It's obligatory. It has to happen. So my learned friend will make that submission in due course. My learned friend's written case focuses entirely on the consequences of the registrar's letter. It's common ground, of course, that the registrar did not perform the paragraph 3 function. She wasn't in a position to perform the function because she didn't know who the applicants were.
Well, I suppose that's true, although she thought she was performing the function, it seems, at an early stage without knowing that.
She couldn't have thought she was performing the paragraph 3 function was properly understood, perhaps, if I put it that way, my lord. And that's common ground. It's common ground that that letter was defective to the extent that it purported to be a paragraph 3 finding. So my learned friends say says that that letter applying Majera, also known as SM Rwanda, is a judicial act and that we can't now go behind it. So we have Majera at page 2603 of the bundles. And of course, I'm mindful that my Lord Sales and Lord Legate, I think, were part of the panel in Majera, and so that was no better than I could ever purport to. But we see in the head note, of course, the applicant was detained.
Just give me the page.
Of course, 2603. The applicant was detained under immigration powers, applied to be released on bail. The Secretary of State sought a condition that the applicant be prohibited from performing unpaid work whilst on bail. That was not imposed by the tribunal, but later the same day an immigration officer gave the applicant a notice imposing that same restriction contrary to the first-tier tribunal's decision. And the Secretary of State argued she was entitled to do so because the bail order was legally defective for a different reason, namely that it failed to impose the relevant statutory requirement that the applicant meet with an immigration officer. Lord Reid gave the judgment of the court. He said in paragraph 1 at page 2612 that the appeal raises a question of constitutional importance, whether the government or indeed anyone else can lawfully act in a manner which is inconsistent with an order of a judge which is defective without first applying for and obtaining the variation or setting aside of the order. We see in paragraph 44 in particular, under the heading, the duty to obey court orders.
Can you give us the page?
And page 2622. It's a well-established principle of our constitutional law that a court order must be obeyed unless and until it's been set aside or varied by the court or conceivably overruled by legislation. And the principle was authoritatively stated in Chuck and Kramer. And then we have that citation at the bottom of the page, 2622. A party who knows of an order, whether null or valid, regular or irregular, cannot be permitted to disobey it. It would be most dangerous to hold that the suitors or their solicitors could themselves judge whether an order was null or valid, regular or irregular, that they should come to the court and not take upon themselves to determine such a question, that the course of a party knowing of an order which was null or irregular and who might be affected by it was plain. He should apply to the court that might be discharged. As long as it existed, it must not be disobeyed. So that's relied on by my learned friend. And I say two things. First of all, in my submission, that the letter of the registrar is not very easily to be equated with the order of a court following a dispute. It's not a determination in that sense. It's not the binding disposition of an issue between the parties. It's also rather difficult to see on whom it would be binding because, of course, one of the problems is it wasn't properly served on the appellants because the appellants were unidentified. So it really doesn't feel like, to me, at all like a rule of law, obey the court kind of problem at all. The big problem here is that notice of the intention was never given in the first place. That's the main problem. And paragraph 3 really has nothing to say about that at all. Even if I'm wrong on that, and Majera does apply, then I say that the board today has the relevant power to consider the registrar's letter. And although there is provision, obviously, under the normal Privy Council rules to apply for decisions of the registrar to be set aside or appealed against, I do say that this board plainly has the jurisdiction and power to consider the acts of the registrar. So if I had to say that the registrar's letter needed to be dealt with in some way in your lordship's judgment, which I don't think I do, I would say that your lordships plainly do have power to do that. We have two cases in the bundle. They're not squarely on point, but they are related to the functions of a taxing master and the registrar of the Court of Appeal. The first is Singh, in which Lord Wolfe, at page 28 6.3 said that the High Court has an inherent jurisdiction to control the exercise of authority of the court delegated to a taxing master. And the second is Prankard, which is at page 2790, in relation to the Registrar of Civil Appeals, who'd said that there was no possibility of further litigating an appeal, so that was dispositive. And the Court of Appeal, of course, said that it had power to decide whether that was right or not. So I say that's a bad point. So that's his first point. And then the second point is non-compliance with paragraph 3 is a Synergy style point. But of course, that's deliberate misdirection, if I can put it that way, because we're not focusing on paragraph 3. The question isn't whether there's been compliance with paragraph 3 or not, from my perspective. The problem is that no notice was given of the intention to seek leave to appeal. It's a paragraph 1 problem, not a paragraph 3 problem. In a world...
If it had been a proper notice, the email of the 5th of November, one might construe the responses to it as acceptance of it by the registrar.
Quite well. They're unlikely to be jurisdictional in this sense because they're not highlighted in section 12 sub 3. We know that they're not time limited. They don't carry with them any of those indicia of importance, the paragraph 3 function. But we're not focusing on 3, we're focusing on 1. So that's issue 2. We say that no notice was given of intention to apply for leave. Issue 3 is the timeliness of the application for leave to appeal. So if we open up the measure again at page 1613,
Would it, if the 5th of November had been valid notice, would it have been in time?
yes.
So does this point add anything?
Oh, to my case, no. If my learned friend is right on issue 2, and they did give valid notice of an intention, and the registrar's notice is valid, then time began to run at the date of the registrar's notice, their letter of the 29th of October.
But that would require their original email being that starting time running, which
It would.
I thought rather obviously doesn't.
Well, that's
And
my position.
there isn't really any difference in terms of identifying the party between that and the later communication on the 5th of November, is there?
There's no difference at all.
There's no difference. So, I mean, they might as well put their best case, which is the 5th of November, in which case this point wouldn't arise.
So this timing point is in relation to the subsequent application for leave.
Yes.
So this point, it does have a separate existence.
Okay.
It relates to it is an elaborate procedure, as many boards before this board have had cause to remark in their judgments. It's an extremely elaborate procedure, and I do appreciate that. But we have issue 2 that relates to giving notice of the intention to apply for leave. No notice was given, but the only communications were in time, so there isn't a timing point there. There were just those 2 emails, 28th of October, 5th of November, both in time. Neither identifies the appellant. Then we have the communication from the registrar. That sets the 28 days running. On my learned friend's case, my learned friend says that letter was effective under paragraph 3. It sets the 28 days under paragraph 4 running. So they needed to put in their application for leave within that 28-day period, and they didn't. So that's a separate freestanding error. It's true that on my case, if I win on issue 2, we don't get that. But it is a freestanding error. So we've got the measure.
I mean, again, sorry, just to make it clear. I mean, what you're focusing there on is the distinction between the 2-stage process under Schedule 2, that you, first of all, go through the filter mechanism of indicating that you intend to apply for permission to appeal, and you say there's a problem with that, not a timing problem, but an identity. But even if you get through that, there's then a separate time limit for actually applying for permission to appeal. And here, as I understand it, you are relying on the timing.
This is a timing point.
Right.
I was just making the point, though, that the better way for the Helen tried to put at least, would be to rely on the 5th of November email, the response to that from the registry as a notification, and then time running from there.
It's true that there may be a construction of the facts. I'm not sure what the response was from the registry to the 5th of November. There was certainly nothing equivalent to the 29th of October letter.
No.
It may be that that's more curable for the reasons that your Lordship and I have already discussed.
Anyway,
Paragraph
taking this
3
as a freestanding
Yeah, it's a freestanding point.
It really runs to the extent that the appellants rely on the 28th October email and the 29th October letter from the registrar.
Absolutely.
That's the way you put it.
Absolutely, and that is how they put their case.
Yes. Okay.
I don't know if I can take you to...
No.
So they do rely on those two things, and they say the 29th of October is that judicial act. It's valid, binding, it can't be challenged now before this board, and so 28 days began to run then. Paragraph 4 of the measure, I gave your Lordships the reference to a moment ago to page 1613, but just to refresh our memories. Within the period of 28 days, beginning with the date on which an applicant for leave to appeal under Section 12 receives a notification under paragraph 3 from the registrar, he or she shall lodge in the registry of the Privy Council 5 copies of the application for leave and so on, and it specifies what needs to be in that document. And then if we go back into the body of the measure, Section 12 again, page 1487, this Section 12, sub 3. I took you to A last time, that's the failure to give notice of intention, and now I'm in B. No application for such leave is made within the period prescribed by paragraph 4 of Schedule 2. So it's the 28-day period prescribed by paragraph 4. If no application, for such leave is made within that period, then we go to the bottom again. The Commissioner shall seal a copy of the draft scheme and so make the scheme. So, as we've just discussed, as recorded in the SFI, as far as the facts are concerned, the PCC and the Reverend Yvonne Clark, this is paragraph 78 of the SFI, page 970, they contend that the purported notice given by the registrar on the 29th of October 2021 was valid and effective notice to both of them under paragraph 3 of Schedule 2. So that's their case. On that premise, time to lodge the application for leave to appeal expired on the 26th of November 2021, and the application for leave to appeal was in fact lodged on the 3rd of December 2021. So those are the core facts giving rise to the lateness, but I will take you back to the email exchange that we've looked at a couple of times now, at page 747. So we have the 5th of November email. So it's a bad reference, 750. Page 750, we have the 5th of November email, which we've already discussed. Then a response on the 9th of November, the registry responding to say, please complete Form 1 and return the relevant fee. Then on the 22nd of November, you see at the bottom of page 749, another email from Lee Day saying thank you very much for your time on the phone earlier, and asking whether someone can confirm that that notice of the 5th of November, I say invalid because it doesn't identify anyone, but anyway, the 5th of November email, whether that had been accepted. Going up page 749, the registry responds saying, as explained, you should file the application in the usual way, and if we require you to apply for an extension of time, the office will tell you. And then Up at the top of the page, and going just onto the bottom of page 748, we see an email from Lee Day to a representative of the church, forwarding that correspondence, which thus far had not had the church as a party to it, the commissioners weren't party to any of that, asking them to agree that notice was provided on the 5th of November, and so, it says, in line with the notice rules, we would provide our grounds 28 days after our notice of intention to appeal was lodged on the 3rd of November, 3rd of December before 4 p.m. signed by council. I don't know if your lordships have that halfway down that email. So, pausing there, that's obviously a misreading of paragraph 4, because time doesn't start to run with the time of the lodging of the notice of intention to seek leave. Time starts to run with receipt of the paragraph 3 notification from the registry. So that's a misreading of the measure. And it's said, and will be said, I think, by my learned friend, that the rules aren't very clear and that the lawyers made an understandable mistake in the light of the registrar responding to the email of the 28th and then not responding subsequently. But in my submission, it's unfair to say that the rules aren't clear. Paragraph 4 is clear, is plain that time begins to run from notification from the registrar. And I can see, of course, that on the facts of this case, a lawyer might have thought, well, look, there are two alternatives. One is that 28 days began to run with the letter of the 29th of October. The other is that there's yet to be any paragraph 3 notification at all. But what no one would have thought, or the objective reading of paragraph 4 could never be that time begins to run from the making of the 5th of November notice. So 28 days from the giving of notice by an applicant of their intention to seek leave to appeal. That's not the right trigger.
What is the trigger if the correct analysis is that the notice was given on the 5th of November and the registrar never issued a notice in response to it?
So if the 5th of November notice was valid, so if it did identify the applicants, or if your lordships take the view that it didn't need to, then I would suspect that the registrar could be directed now to exercise her paragraph 3 functions, because they're not of that jurisdictional nature. And perhaps one could have some kind of concertinaed process subsequently. But that would, of course, mean that your lordships would have to take the view that the notice of the 5th of November didn't need to specify. It could be anonymous, essentially.
So there'd be no time limit problem?
There'd be no time limit problem, that's right.
I mean, interestingly, that actually seems to be what Lee Day were asking for if one looks at page 750, because they're almost correcting the registrar. They're saying, well, you came back and treated us as having issued our intention of notice to apply for permission to appeal, but we didn't do that, but now we are, and please treat this as the notice of our intention to apply, i.e. at the first stage, not the second stage.
Absolutely, my lord, I agree with that. And I think that was a confusing exchange with the registry. It was confusing. But the question then is to read paragraph 4 and to form a view on how it applies. And there really is no way in which one would arrive at the date 3rd of December.
Sure, but if things were as Lee Day were inviting the registrar to treat things, then we're in the realms of no relevant paragraph 3 decision having been made, and so the timing issue would fall away.
Yeah, I think that's right. I think that's right, and that does require, of course, your lordships to hold that the 5th of November email was proper notice.
Yes.
So that's the fundamental point, I think.
That's the point.
It emerges as the fundamental point.
It does emerge as the fundamental point. I think that's right, my lord.
I mean, it's clearly on behalf of Lee Day's clients, but we don't know who they are.
We don't know who they are. There were 40 persons, I think I'm right in saying, who made written representations against the scheme. The PCC, obviously, we say wasn't one of them, so one can assume they weren't one. One doesn't know who they were. Appellant was used in the singular in the email from Lee Day rather than appellants.
I mean, your point is that you don't know who they are,
Don't know who they are.
and you really can't expand on that.
No.
And of course, I mean, plainly, I hesitate to make this submission, but plainly this is a matter of construction of the regime, not construction of this case, and I took your lordship to some of the authorities on that point. Either a notice does have to indicate on whose behalf it's made, or it doesn't. And if it doesn't, then that will be the way that we apply this scheme going forward. In, as you'll hear when I get to the submissions on substance, a challenging mission environment in which these schemes are sadly not uncommon. But if it is the case that notices can be made anonymously, that is of course something.
Well, I suppose that there would still be the registrar could say we don't accept it because we're not satisfied that it's given on behalf of people who duly made written representations.
That's right, my lord, but we have section 12 sub 3 that says if no notice is made, we make the scheme. And I know that didn't happen in this case.
No, I do understand your point.
Yeah. So
Ms Wakefield, I'm very sorry, my computer has taken it upon itself to shut down for reasons that I don't understand. I just need to restore it. I'm sorry about this.
No, of course.
Doesn't seem to be. Yes. Well, shall we see how we go? And also, I've got a fair amount of stuff printed out. Let's see how we go. So,
Please continue, and if Lord Sales, if you're referring to matter that Lord Sales needs to look at, which he hasn't already got in front of him paper, then we may have to adjourn to have this problem resolved.
sorry.
Thank you.
So we're in this email exchange. And the Commissioner's reply on page 748, or representative of the Church replies, saying, we can't agree the correct date, Liday having asked us to agree that it would be the 3rd of December. We say we can't agree the correct date, confirm we're in the court's hands, but we say we wouldn't object to the court deciding that the 3rd of December is the right day to provide the grounds. And of course, I do acknowledge that there's been a change in position, that we are now objecting. Of course, it's a legal matter, and the representative of the Church at that point didn't purport, I think, to give legal advice on the correct approach and said it was a matter for the court. But of course we accept it's highly unfortunate that we said we'd be okay with the 3rd of December when in fact the regime can't bear that interpretation. We have further emails with the registry on the 23rd of November. In the SFI, it's not apparent on the face of the emails, it said that on the 2nd of December there was a conversation between Liday and the registry to confirm that the 3rd of December was the agreed file-by date. We weren't privy to that, we didn't know it had happened. But in any event, of course, time had already in fact expired, if time does begin to run on the 29th of October. So at that point, too late anyway.
Sorry, which was the paragraph in the
On the SFI, it's paragraph 88 on page 973. And then the application for permission was lodged on the 3rd of December, and that application included an application of extension of time, if not. So, turning to my submissions, my learned friend accepts that the application for permission to appeal was out of time, and he needs a power to extend time. So, submission 1, he says, is that there's a general power to extend time on the face of the measure. I say that's plainly wrong. Shall I?
Yeah, do you want to just pause? It's going to be very distracting for you. Let's see if we can sort it out very quickly. Okay, so just go through it. If you wait hearing. Sorry, just bear with me a second. It may correct it. Something like that. Very good.
Technology has improved the way the board works, when it works, but not when it doesn't.
Well, it does seem to be starting, but slowly, so just bear with me if you would. Right, just bear with me while I get the documents back up again. Yes, thank you very much. I'm sorry about that.
No, not at all.
Thank you.
So I say there's no general power to extend time. I've taken you now to section 12 sub 3 on various occasions. You'll recall that sub B, the provision which I'm relying on in this case, expressly has baked into it reference to the time period set out in paragraph 4, it's that 28 days. And you have my submission as well that there are other aspects of the regime in relation to which a power to extend time is conferred. And so one can compare and contrast between those different provisions. The cases which are relied on by my learned friend in his case, re X, re A, are family law cases in a very different context, in a different statutory regime. Doubtless my learned friend will address them when he's on his feet and I can come back to them in reply. But I say the basic principle, which is that when there is a time limit expressed in this way in a measure, in a piece of legislation, where elsewhere one finds powers to extend time, one doesn't here, and it's coupled with a synergy indication of what should happen if time isn't complied with, move straight on and make the scheme, that really is entirely dispositive of any argument that one might have a general power at large to extend time here. And we see in general, of course, and your lordships will be very alive to this, that in many cases in which there are time limits in relation to a jurisdictional requirement, they are construed, or to say strictly is wrong, they're construed as they mean. They're construed in compliance with the wording of the statute. In the bundle we have Crown and Weir, which of course predates Synergy, but in my submission remains good law. Pomichovsky, which I'm going to come to, Maiden, Croak, which I'll come to shortly, Adesina, Stewie. In all of those cases, one ended up in Article 6. And the reason one ends up in Article 6 is because there is no general discretion to extend time available on the face of the legislation.
Where do we find the powers to extend time?
So, in the measure, which is at page 1468, we have a power to extend time, which I took your lordships to earlier in section 9.5, which is the Commissioner's power to extend time for written representations. And then we have in section 2, six, and I think it's paragraph 6 and 11.
Schedule 2.
Schedule 2, sorry. So page 1620. This is leave's been granted, and it's the time limit for filing a petition. And it's at this point that dismissal for
Sorry,
non-prosecution.
paragraph 6 of Schedule 2, did you say? So which paragraphs did you say?
Sorry, paragraph 6 and paragraph 11.
Right.
So paragraph 6 relates to notice of leave to appeal having been granted, being served on the applicant, and the
without
requirement
delay.
then, exactly, to file their petition. And that's subject only to a without delay provision.
What is it in paragraph 6 you're relying on?
So it's 6 in combination with 11.
Oh,
so
in
it's
combination
11.
with it.
Okay.
Yeah, absolutely. No, sorry about that. So in 11,
So, within 3 months.
yeah, so fails to lodge within 3 months or such extended period as the registrar may allow. And we also see that failures to comply with timeless lodging of the petition, for example, are dealt with in that softer way. But then if no petition is lodged, even in compliance with that extended deadline, we're back in section 12 sub 3. And so sub 3 is now we're in little d. The appeal stands dismissed for non-prosecution by virtue of paragraph 11 of the schedule. So you see in my submission it is fairly carefully calibrated. For some you get more time, for some it's just the time that's set out, and then at a certain moment, chop, the guillotine comes down.
So there are 2 express provisions for extension of time. is
2
that right?
express provisions.
One
and
in
also
9.5, section 9.5, and one in paragraph 11.
Exactly so, my lord. And there is, of course, the exercise of the paragraph 3 discretion itself, or function itself, which is not time limited, so that's the registrar. And presumably, in a case in which the registrar failed to exercise the function, ultimately one could apply to the board for directions, presumably, but that's not time limited. So we have Croak in the bundle, which I'll take you to quickly. I'm quite mindful of time, but that's at page 1924. As we see in the head note on page 1924, the claimant applied for leave to challenge the decision of a planning inspector. The 6-week time limit for the challenge expired on a Wednesday before a bank holiday. The claimant missed his train. He emailed the documents to someone, asked them to file the claim, and when that person arrived at court at 4:25, he was ultimately not allowed in. The relevant provision is set out in paragraph 5. That sets out the 6-week time period. Then we have in paragraph 6, ample case law on the effect of time limit provisions such as that established in subsection 4b, traditionally been regarded by the courts as immutable, sets out that long line of authority. And of course this is a recent decision of the Court of Appeal 2019. Paragraph 31 get to the court's considerations of the general discretion, if I can put it that way. Having considered the authorities, the court holds that Parliament has provided a strict time limit which is precise, unambiguous, unqualified and mandatory. Parliament intended to avoid uncertainty and inconsistency likely to occur if the time for making an application was subject to the court's discretion. And in paragraph 34, we also see the Lordship taking into account the obvious difficulties where one has a case where the interests of numerous parties are engaged, sometimes a large number, quintessentially planning disputes, and the public interest inevitably being engaged. And in proceedings of that kind, certainty and consistency in the operation of fixed statutory time limits being particularly important. And of course, I say that that reasoning is entirely transplantable to my case, so far as general discretion is concerned. While I'm here, I'll just go to the Article 6 paragraphs as well, which are in 48 and 49. His Lordship addresses Pomichowski, that's page 1943 and 1944.
This was a pretty tough case because the court was meant to be open when the person turned up, is that right? But they closed early?
They closed 5 minutes early. It was 4:25 and the security guard wouldn't let him in. And so one sees the litany of things that went wrong in paragraph 48. Various things went wrong, missing the train, sending an email and mistyping the email address, and then of course this 4:25, 4:30 aspect. And His Lordship does say that it's wrong to isolate that. Those 5 minutes is the only thing that went wrong that day. Various things went wrong, and that wasn't the sole cause and effect. And His Lordship holds, taking into account Yardley as well, that this isn't one of the cases that falls within exceptional circumstances, Article 6. Even though, of course, a hard case in the sense that the claimant in question was doing his very best to comply with the actual time limit on that day in question, I suppose, save for missing the train and mistyping the email address.
Well, none of those would have mattered if the court had opened as it should have been. So.
Quite so. Quite so. So if I turn then away from the regime itself, which I say is plain and straightforward and does exactly what it says, and what it says is very sensible, if I turn to what would happen if Article 6 were to apply, I say, of course, it's not engaged, but if it were to apply, plainly it wouldn't require an extension of time in the present case. So if we start with the relatively recent judgment of the Court of Appeal, which I'll pronounce Stewie, but I may be mispronouncing it, S-T-U-E-W-E, that may not be how I should say it, but it's page 3142. Again, a judgment of Lady Justice Carr, as she then was. And as per the head note, this concerned an appeal by a paramedic against a finding of misconduct. The relevant legislation provided for a period of 28 days in which an appeal could be brought. The appellant sought to file notice of appeal, including within that time they were rejected because he didn't provide an address for service in the UK. And he said the delay was caused by difficulty in obtaining funding and legal advice. So if we have a quick look at paragraph 29, because there is some similarity with the email which we sent in the present case saying we wouldn't object to the 3rd of December. So this is an email from the head of the fitness to practice of the JCPC, and on the top of page 3146, she says, I appreciate that you're out of time, but if you do intend to proceed, we won't take a point about that. And just following that through the judgment, in paragraph 34, the Court of Appeal says that the first instance judge was entirely right that that email could not clothe the court with the jurisdiction that it did not in fact have, and that it was open for the HSPC to resolve in its position. And obviously this is all unfortunate that for jurisdictional matters that is the right approach. And we see again, paragraph 65 at the very end of the judgment, that that email could not create a jurisdiction that did not exist. Then in paragraph 42 on page 3147, we see 41, we see the relevant provision that any appeal has to be brought within 28 days. 42, the appellate court traditionally was viewed as not having the power to extend that period. And then, of course, we come into Article 6, Tolstoy and Miloslavsky, we see in paragraph 44. Then paragraphs 45 and 46, we see Pomiachowski and Adesina, and that the discretion must only arise in exceptional circumstances and where the applicant personally has done all he can to bring the appeal timelessly. I do not believe that the discretion would arise save in a very small number of cases. I'm going to come back to Pomiachowski shortly because of its relevance to surrogacy. In paragraphs 48 and 49, she makes the point that it may, in this context, be rather odd to speak of a discretion, because obviously the Article 6 question is what is it that the court is obliged to do to comply with Article 6? And that gives you a certain answer, and once you've got the answer, the court has to do it. So it's really generative of a duty, not discretion. In paragraphs 50 to 52, and this is one of the reasons why I need to take your lordships to this case, the Court of Appeal says that there is no longer, and in fact it was a misreading ever to think that there was a separate and independent requirement for Article 6, that a litigant must have done absolutely everything they could do, that that's a gloss on the test, but that exceptional circumstances are unlikely to arise if they haven't. And then in paragraph 54, we get the core statement of the test. The central and only question for the court is whether or not exceptional circumstances exist, namely where to deny a power to extend time would impair the very essence of the right of appeal. And her ladyship goes on to explain why in that case the facts were not sufficiently exceptional and the core value of the right was not impaired. So in our case, I say that the PCC and the Reverend Devon Clark had ample opportunity to file their case on time. There's no reason at all, no impediment, no cancelling of the trains, no wrong email, why they weren't able to meet the deadline of the 26th of November. And they don't identify an impediment in that sense. So the way they put their exceptionality case is that it was a mistake of their lawyers, and that mistake was at least slightly contributed to by the court and by us, that it was a mistake of their lawyers. And we know, of course, that the overwhelmingly general position in Strasbourg is that that doesn't constitute an exceptional circumstance, and that Strasbourg applies the conventional principle of surrogacy. So namely that the person is treated to be responsible for the errors of the lawyers, or to put it in the language of Strasbourg, that the UK, the state, should not be treated as responsible for the errors of lawyers, to put it that way around. So we have Clavian in the bundle, which is page 3496. This is translated, and the translation starts at 3504. So, paragraph 16, if we start there, the deadline for appealing against the decision of the relevant cantonal supervisory authority was 10 days. And then in paragraph 17, we see that the applicant erroneously had relied via their lawyers on the 30-day deadline that was set out in the judgment being appealed against. So such was the involvement of the court with the relevant error that the judgment itself that was being appealed against said on it, you have 30 days to appeal. And that was wrong, they had 10 days. But nevertheless, Strasbourg said, well, you're stuck with the error of your lawyer, who should have spotted that. And so we see in paragraph 23, errors committed by the applicant's representatives do not in principle mean that the authorities will be held liable under the convention. 24, on page 3509, the applicant was represented by a lawyer within the context of the proceedings, and it highlights it was the same lawyer who had represented them throughout, likely to facilitate monitoring of the case. And then we see 25, the appeal deadline clearly provided for in the relevant article of the code, in that case, had not been modified, had been on the books for 7 years. Notes in 26 that although these proceedings, which are about debt collection and bankruptcy, are important, they're not as important as the case of child return proceedings. The reason they're comparing it with that is the Gajtani case, which is the case that's been added to the bundle, an earlier case, which did relate to that. And then in 27, they say specific circumstances were sufficiently taken into account. It's not disproportionate, this is the end of paragraph 27, to require the applicant's lawyer to carry out a summary check of the information on the appeal deadline contained in the cantonal court's judgment. 28, the second sentence, it's incumbent on lawyers to organise their own work in such a way as to best defend their clients' interests. And the monitoring of the case on these facts was easier because it was the same lawyer throughout. So we say so strict, actually, is the approach of the Strasbourg case law on this issue, that even when the court itself gives you the wrong deadline, if the deadline is ascertainable in the normal way by your lawyers, then your lawyers should have worked it out. And there's no Article 6 problem. In the light of time, I'll go to Gajtani in reply if my learned friend relies on it, and instead I'll go straight to Pomichowski now, which is at page 2291. And of course, this was an appeal to the Supreme Court concerning compliance with the short and, at the time, inflexible time limits in relation to appeals under the Extradition Act. Under paragraph 3, notice of appeal, let's find, that's on page 2298. Notice of an appeal under this section must be given in accordance with the rules of court before the end of the permitted period, 7 days starting with the day on which the order is made. Paragraph 5 in Mucelli, the House of Lords held that meant filed and served. In paragraph 17, which is on page 2303, Lord Mance considered departing from Mucelli. Now, the reason I take you to paragraph 17 is that my learned friend relies on it in his case. Because Lord Mance says, well, I could say that, and say that it no longer needs to be served as well within the deadline, but that wouldn't answer other hard cases. And he gives, as an example of a hard case, negligence by a solicitor. But he goes no further than that, and he plainly doesn't say all cases of negligence by a solicitor now should give rise to Article 6 exceptional circumstances. That would be flatly contradictory with the Strasbourg authorities. Paragraph 18, statutory notice period interpreted generously on the facts of, or by reference to the circumstances of that regime in particular. Paragraph 19, it disposes of the appeals in that case because notice of the form that actually we've been talking about today, notice which at least indicates this is my name and I am intending to appeal, that sort of notice is enough for the statute. It's not enough under the rules, but under the rules these things can be corrected and corrected timelessly. So the statute is complied with, so we're not in synergy invalidity. Paragraph 33 takes us to Article 6. So that's in relation to one of the appeals in relation to which Lord Mance couldn't apply that statutory construction because the CPS also needed to receive notice and nothing had been sent to the CPS. So there was no way in which the statutory requirement had been complied with. Paragraph 33, he says, well, these proceedings fall within Article 6. The present provisions in paragraph 34 don't meet Tolstoy and Miloslavsky. And then in paragraph 36 and 37, these are the most important for present purposes. So he says there is no absolutely universal surrogacy principle. That's not non-derogable. You can on occasion depart from the idea of surrogacy. And in paragraph 37, he sets out the reasons why, by reference to that regime, it's necessary to confer, when the facts demand it, an Article 6 ability to extend time. That's because of the potential and actual unfairness of the position in which prisoners find themselves with such aid as the Prison Legal Services Department or legal advisors can, under difficult conditions, he says, provide, with the problems of communication, with the fact that monetary relief, in this particular context, plainly no answer. And so he says that in that context, strict application of surrogacy would potentially be unjust, and so there is that exceptional power to extend time. So in my submission, that is very much focused on that particular legal regime. 7 days, you're in prison, very difficult to access lawyers at all, communicate with them, give them proper instructions, supervise them. So surrogacy mitigated in that context, but in general, overwhelmingly, surrogacy applies. And so the Article 6 case, I'm afraid, is just, it's dead in the water. And for that reason, I say that there's no general discretion for the reasons I've already said. Article 6 is dead in the water. I also say Article 6 doesn't apply. I rely in that regard, not least with my eye on the clock, on paragraphs 15 and 47 of my written case. But you'll have seen principally that's by reference to a case called Artinan, which is about the decisions within religious organisations, such as transferal of priests. I can address you in reply if I need to on that point. So those are my submissions.
Sorry, and that last point is what, to say this isn't civil...
It's not a civil right, it's not a determination of a civil right or obligation, absolutely, my lord. I don't develop my case beyond what's in those paragraphs.
Paragraphs were?
They were...
You say 15 to
15 and 42, my lord.
15 and 42?
And 42.
42, thank you.
Yeah. Then issue 4, I'll take very lightly because I've hopefully laid the ground for it, and it's a narrower point in any event. So, 3rd of December, the application for leave is made at court, and it's made using the Form 1. If I take you to that document now, it's at page 812. And one sees page 812 in the proceedings between All Saints Spring Park Parochial Church Council and no identification of the Reverend Yvonne Clark as an appellant. One sees that over the page, 813, details of the party appealing. All Saints Spring Park Parochial Church Council, no identification of the Reverend Yvonne Clark. Page 816, details of additional party, again no indication of the Reverend Yvonne Clark. But we do see later on some references to her, so I very much obviously want to put this point as fairly as I possibly can. So at page 827, this was filed with the Form 1. Top of 827, we have the appellant singular, All Saints Spring Park Parochial Church Council and the Reverend Yvonne Clark, so the first time we see a reference to the Reverend. And then on page 829, we plainly see her identified at the top of the grounds of appeal as one of the two appellants.
And paragraph 1 is pretty...
Absolutely.
Couldn't be plainer, really.
Yeah, absolutely. So through the body of the submissions, we see that she's referred to, but in the Form 1 document, we see that there's no reference to her. And so really this is a very short point. The point is simply whether, applying the cases which we considered earlier, the notice cases, whether the reasonable recipient of the Form 1 would have understood that one of the appellants was the Reverend Yvonne Clark.
But the reasonable recipient would receive not only the Form 1, but also the grounds of appeal with it.
Quite so, my lord, quite so. So in that sense, it's similar to the Newbold Coal Authority case, in which, of course, it was held that the reference to the brothers in the addendum document was enough to inform the identity of the claimant. And so that's against me. A difference between this case and Newbold, of course, is that in the Newbold case, the three brothers were jointly owners of the relevant damaged property, so naturally one might have thought they would all appeal, whereas in this case, the question really was at large, who is appealing? And one sees in the emails with the registry always the use of the singular. But this is very much, as I say, a narrower...
Could we just go to page 848?
Of course.
So, page 848.
Yeah, absolutely, my lord. So...
These are your objections to the grant of permission to appeal.
Quite.
So your clients clearly understood that the Reverend Yvonne Clark was one of two appellants.
Absolutely, in the submissions, yes, but if we go to 842...
Well, one sees the heading.
One sees the heading, of course, and in 842 we only said All Saints, Spring Park, PCC, and not 842. So this is the equivalent bit of the Form 3 that corresponds with the part of the Form 1, if your lordship gets my meaning. So there we are.
Yeah.
And this may be seen perhaps contextually, I suppose, as the last moment in a confusion that has infected the facts throughout all four of my jurisdictional points.
I don't think your clients were ever misunderstood the position, though, did they? I mean, I noticed that on page 748, in an email from your clients, they refer to the appellant and her appeal or her submissions.
So on occasion, both sides have used singular. On occasion, they've used a she. On occasion, a they.
Well, I mean,
there is a confusion.
We don't object to the court deciding the 3rd of December is the right day for the appellant, singular. Sorry.
So that's sorry.
To provide her grounds.
So that was...
I mean, the point I'm making is that your clients knew perfectly well she wanted to appeal.
That's not right, my lord, because at that stage in the email correspondence, that was before we had any indication of who the appellants were.
Yeah, but you're assuming it was her.
At that point, we thought, presumably, that it was her, but my learned friend's written case is that the 5th of November notice was given only by the PCC, not by the Reverend Yvonne Clark. So what one sees is a confusion at all times. Who has standing, who's exercising the discretion in relation to who's got standing, who's given intention. And these points, they may seem like technical points, but in my submission, they're points of real consequence for the regime, real consequence if in fact the draft scheme should have been made considerably earlier than it was made.
But why is issue 4 of real concern to the scheme? If you're saying that one has to interpret Form 1 on the grounds of appeal in a way that a reasonable party would interpret them, and then we go to see the Church Commissioner's response, and they knew jolly well that it was the PCC and Reverend Clark.
I see that, my lord. I see that. The difficulty comes when one gets to the substantive arguments and one's considering the standing and the nature of the human rights arguments in particular, and then one thinks more about who the appellant is. But I absolutely acknowledge that our response in the Form 3 was drafted as it was, so I do see that.
Yes, but it only relates obviously to issue 4.
It relates, it's an issue 4 point. It's just an issue 4 point. And we have 1, 2 and 3 on which I've already addressed your lordships at some considerable length. And unless I can be of any further assistance, my lords.
Thank you very much. Mr. Thomas, quite a lot of time has been taken up by the respondent on jurisdiction through no fault of her own, because there were heavy points to be covered. So the board would welcome after lunch a statement from the parties as to how the rest of the time is to be allocated. Thank you very much.
My Lord, yeah. My Lords, I hope that I won't be as long as I had originally anticipated, because some of the law has been set out, some of the facts have been touched on.
Sure.
So I hope I can take this slightly shortly. I would ask my Lords to just bear with me just for a few minutes while I set out the structure I will be turning to some of the points of concerns that my lordships have raised. I'm not quite articulating my argument in the same way that my learned friend has structured it, but bear with me, the points will be answered. I do say this, the jurisdictional points were raised late, and one of the reasons why I say that is important, it touches upon the very last point that was made. No issue was made, there was no issue, certainly up until the 19th of April 2023, as to who the parties were or who was bringing this appeal. And I take your lordships, just for your reference, have a look at page 796 to 805. That's when the jurisdictional issues were first raised. So I give you that just for your reference. However, I don't dispute that now it has been raised, your lordships have to deal with it. Can I start with an overarching point made by the commissioners about the non-compliance with the statutory measures? The commissioner's submission, as I understand it, is Simonje is simply inapplicable to this case because of the 2011 measure. It spells out the consequences of non-compliance, and that's spelled out in section 12.3. And already reference has been made to Shahid, that's page 3047, and Troll Riders, which is at page 2745. However, in terms of my overarching submission, I say that the proper approach to the construction of the statutory procedural requirements is not as absolutist and literalist as my learned friend suggests. And I want to take you to a case which we say is of central importance, and that's re-ex parental order, and you'll find that at page 2995. That's page 2995. And there you'll find a magisterial judgment by Sir James Mumby, then the President of the Family Division. The case concerned the statutory time limit for applying to the court for a parental order under Section 54 of the Human Fertilisation and Embryology Act 2008. And I want to draw your lordship's attention to the wording of Section 54, which the President set out at paragraph 14 of his judgment on page 3000. And I'll just give your lordships just a moment just to turn that up. You see, my lords, on a literal reading of the wording of this section, it appeared to be absolute and unqualified by section.
Which bits do we go to see that?
Which subsection?
Subsection 1C, the power to make a parental order. Under subsection 1 only arose if conditions in subsection 2 and subsections 8 were satisfied. Under, sorry, Lords, do tell me if I'm going too fast. Under subsection 3, one of the conditions was that the 6-month time limit had to be complied with. If it was not, the court simply had no power to make the order. Now, you might think this was a case where the plain and unambiguous terms of the legislation made the time limit absolute. Yet, this did not stop the President concluding that paragraph 52 of his, this is paragraphs 52 to 57, and you'll find that at pages 3011 to 3013, that Parliament did not, in fact, intend an absolute time limit. And he specifically said, at paragraphs 56, quote, I've considered whether the result at which I've arrived is somehow precluded by the linguistic structure of section 54, which provides that the court may make an order if the relevant conditions are satisfied. I do not think so. Slavish submission to a narrow and pedantic reading would simply not give effect to any result that Parliament can sensibly be taken to have intended, end quote. Now, in my submission, what my learned friends are asking you to adopt in this case is precisely what the President deprecated in this passage: slavish submission to a narrow and pedantic reading. Learned friends heavily rely on Shahid to make their point. Let's turn to that case. And you'll find that case, my lords, at the passage I want to take you to is 3060, which is paragraph 8. This case, as your lordships are aware, concerned the requirement of the prison rules set out at paragraph 8, at 3060 to 3061, which prevented a prisoner from being removed from association for more than 72 hours, unless the Scottish ministers had granted written authority before the expiry of a 72-hour period. True, it is that their lordship said at paragraph 20 that this was a case where the consequences of failure to comply were eluctably spelt out by the legislation itself, and where the court could not disregard the, quote, plain and unambiguous terms of the legislation. You see that at page 3063.
Paragraph 20.
Paragraph 20. But context is important. The statutory requirement that had been breached in Shahid was a requirement whose purpose was to protect prisoners by limiting the circumstances in which they could be removed from association. There was every reason to think that Parliament intended a strict reading of the legislation in the circumstances of that case. Lords, note this. Shahid went on to say at paragraph 21 that the plain meaning could only be circumvented if it led to an absurd or perverse result, page 3063. Now, I note that Benyon on statutory interpretation states that, and you'll find that in the supplementary bundle, and that's at tab 9, so tab 9 of the supplementary bundle, paragraph 13.1.
Do you have a page number for that?
Yeah,
because we work from electronic pages.
yes, I do. Just bear with me a second, my lord. 183. 183.
Thank you.
Quote, the courts give a very wide meaning to the concept of absurdity, using it to include virtually any result which is impossible, unworkable, or impractical, inconvenient, anomalous, or illogical, futile, or pointless, artificial, or productive of a disproportionate counter mischief. Now, that coheres well, we say, with the approach of Sir James Mumby reacts, under which Parliament is taken to have intended a sensible result. Now, Lords, I take the point made clear in Packer, and Packer is to be found in the supplementary bundle at page 188, that's page 188, and I take you to paragraph 43 of Packer, which paragraph 43 is at page 203 to 204. The courts can't substitute their view of what is reasonable for that of Parliament. But the issue is, what is Parliament taken to have intended? Let me develop the point in this way.
Well, what do you say the answer to the question is first? What has Parliament intended here?
I say, on the facts of this case, context is important, and what I'm going to develop in just a moment is, this is a case which falls between Shahid and Re-Ex, because what we're dealing with is particular rights, and I'm going to spell out what those rights are in a moment, and therefore you are entitled to look at the context and not read the provisions of the measure in an absolutist way. Let me develop that for you, my lord. just before I do that, can I also just mention the Trail Riders Fellowship case, which begins in the Bundle Act 2745, that's 2745, just to give you the reference. And the first thing to say about the majority of their lordships in that case, that the majority of their lordships held that the procedural requirement in that case had in fact been complied with. And so the observations of the three of their lordships on which learned friend rely are in fact obiter. I note that not all of their lordships agreed with those observations. For example, Lord Carnworth took a more flexible approach. He said at paragraph 69 on page 2764, that procedural requirements such as those in question in that case should be interpreted flexibly and in a non-technical way. And that is precisely what we are asking for in this case. Leyden, the case of Leyden, which is at 2779, that's 2779, cited by my learned friends, does not assist them either. Because I note that in that, this is a case where the statute said the defendant may not be arraigned after the expiry of a 2-month time limit. And you'll see that at page 2785. 2785. Despite this, the Court of Appeal did apply the synonymy, asking what Parliament can be taken to have intended. And you'll see that at paragraph 17. And paragraph 17 is at 2784. So we say the circumstances of that case, the court's conclusion was that Parliament had indeed intended automatic invalidity to flow from a lack of strict compliance, but that conclusion was reached after the consideration of context and purpose. If my learned friends were right about the proper approach to construction, then the second and third sentences of paragraph 20 in Leyden would have been all the reasoning that was required, and the reference to synonge would have been superfluous. But that's not the approach the court took. The language was the starting point, but it was not the only factor. You see, my lords, I know that Leyden, like Shahid, was concerned with a procedural requirement whose purpose was to protect the individual from the state. And in my submission, the considerations of parliamentary intent are very different in a case like the present, where the question is one where the individual is shut out from access to the court because of procedural errors. So let me turn to my submissions. Lords, there is no universal rule that where a statute prescribes consequences for breaching a procedural requirement, strict compliance with that requirement is always required. That is not the effect of the authorities. Rather, close attention to the actual intention of Parliament is required, viewed in context. My learned friends rely on the fact that REACTS relates to, quote, orders which go to fundamental aspects of individual status and identity with consequences that endure for the entire life, because it's under the Human Embryology Act. So I get that, which they distinguish from this case. However, in my submission, it does not follow that it's only in such cases that a statutory requirement may be read as a non-absolute. Here, we are considering statutory requirements which are designed to allow ordinary parishioners to lodge an appeal against a scheme. Such schemes may, as in this case, have extraordinarily significant consequences, such as And in this case, it's putting an incumbent out of the ministry and dismantling an established parish community. The loss of her ministry, in the method by which it's been taken, is a fundamental aspect of her status and identity. Reverend Yvonne Clark is the ministry, and the ministry is her. That is her identity. These matters can have profound, long-term consequences for those affected, which go far beyond the mere financial. And with that in mind, my lords, can I just pause and add this? You will note that in the appeal form, where the box is there a financial claim, it wasn't ticked, because this isn't about finances. Parishioners, we say, seeking to appeal a scheme may have no knowledge of ecclesiastical law, may not be legally represented, and it's my submission that the General Synod and Parliament would not have intended a lack of strict compliance to lead to automatic invalidity against this backdrop. Now, I accept, of course, that if Parliament intended automatic invalidity to follow from the failure to comply strictly with the statutory requirement, then the proceedings could not be saved by merely relying on a lack of prejudice. But we say, in respect of the procedural deficiencies in these proceedings, a close attention to the intent of the General Synod and Parliament is required. In the cases where Parliament did not intend automatic invalidity to follow, the lack of prejudice will be relevant. The North Somerset District Council case makes that clear. At paragraph 47, you'll find the North Somerset District Council case at page 2171. That's 2171, paragraph 47. And I think the relevant paragraph, 47, is 2192. Forgive me if I've given you the wrong reference. Paragraph 50 is at 2192. In my submission, Lords, such an approach is far more likely to be what the General Synod and Parliament intended in the present context. Namely, objectors will generally be ordinary parishioners, often acting without legal assistance and detailed knowledge of ecclesiastical law. So that's a framework. Let me turn to the problems in this case, the specific problems, and deal with some of the issues that the learned friend has already outlined. I want to turn to the specific procedural errors in this case. Now, just as I come to that, I note the time. I'm in your lordship's hands. It's 4 minutes to 1. Do you want me to launch into...
Make a start.
Make a start. So
Thank you.
I start with the notice of intention to seek leave to appeal. Now, there were 2 emails which form part of that thread that's in the bundle, and we've already touched upon them, but for your references, page 746 to 753. We know the first was sent on the 28th of October, and for the avoidance of doubt, this was not intended to be a notice of intention to seek leave to appeal, and I know your lordships have already touched upon that.
That's why I can't really understand why you're nailing your colours to the mast rather than the one that was intended to be a notice. Yeah. Or at least to start off with that benefit. It also avoids the time limit problem.
Let me develop the argument with that in mind. It's clear in my submission this was intended to be an inquiry about the procedure. This was in circumstances where there'd never previously been an appeal under the 2011 measure, and the appellants were hoping for guidance and assistance from the registry as to what needed to be done. And as you know, the second was sent on the 5th of November, still within time, and was intended to be a notice of intention to seek leave to appeal. Now, in the light of the exchange of written cases in my submission, the issues between the parties can be narrowed to this. it is agreed that both notices were defective in that they didn't identify the intended appellant. But the question is the defect fatal to the validity of the notice?
In your written case, you assert that the second one did identify one of the appellants. I don't know if you are maintaining that.
I'm going to... I'm going to develop that. Just bear with me a second. Yeah. What we say is, well, Malone Frank has identified the cases on defective notice Newbold, and that's just for your reference, 2146, it's 2,146, and Pease and Carter. And Pease and Carter is 2273, 2,273. And the position is summarised at paragraph 39 of Pease and Carter, and you'll find that summary of what a notice, what constitutes a valid notice, at page 2,287. I'm not going to read it out, I'll just give you the reference.
Which paragraph?
Paragraph 37. Sorry, 39.
So, paragraph 39, which we saw earlier, yeah?
Yeah. Okay. Paragraph 39.
Yes.
And Malone Friends also rely on Newbold at paragraph 60, and I ask you to make a note of it. Paragraph 60 you'll find at 2,164 going over the page to 2,165. The quote that starts, the third possibility is that my personal assistant. Yeah. Now, in this case, the question boils down to this. By whom would a reasonable registrar, reading the emails in context, have understood the notice to have been given? Can I leave you on that cliff hedge while we go to lunch?
Well, we shall teeter on the cliff edge until the end.
Lunch and breakfast.
Thank you very much.